Hello, students. So today we are going to discuss some more legal updates for the upcoming CLAT and ALED examination. Now, there would be a question. I was receiving some question as to why these legal updates become important. Why do we need to cover these topics separately? Why can't we cover it along with our current affairs and GK? Now, if you would look at the pattern of the question paper, you would realize that most of the question, most of the passages, uh, most of the topics that are covered in the legal reasoning section, somehow or other, they are related to some development. Those topics are related to some developments that are going on currently in the current affair, right? And when we study the GK part, we do not get very much deeper into the legal concepts there. However, when it comes to the legal updates, here we always try to, take out maximum legal verticals out of each topic that we come across, out of all the developments that we come across. Mostly, if you would find any legal update, any legal development, any amendment, any appointment, which have been into discussion in the newspaper constantly, so there are chances that such topic can be a target of one of the passages in your examination, right? So, following the pattern that we have seen in past few years is why we have been so keen towards these legal updates, right? Okay, live streaming of Supreme Court. So recently, there have been a lot of developments in the Supreme Court with regard to the live stream of the procedure, right, of the constitutional bench that sits in the Supreme Court. Now, why does it become so important? Uh, you know that India is going towards digitalization, right? So everything is getting digital these days, and how we were expecting digitalization of Supreme Court or all the courts in the future, but this procedure got expedited because of the pandemic, right? And if you are aware of the fact that there are some Supreme Court lawyers, Supreme Court judges who are very keen towards digitalization, who are very keen towards technology to be used in courts for better efficiency, right? So whenever technology comes into a picture, the efficiency automatically goes up, right? So one of those judges are our Chief Justice currently, who is Justice D.Y. Chandrachud, right? So he is one of the most vocal judges you would see. And there are certain other, you can go through his lectures also, just in case if you're interested. There are certain sessions wherein he has talked about these live streamings and digitalization and technology and putting everything online, these kind of things. He has talked about it during COVID. So now we can see all of that coming into action. So these digitalization, it has been happening in phases, right? Because we need to be a bit slow. We cannot automatically make everything e-code. We cannot make everything digital and technological, right? Because we cannot expect each and every person working in the court, be it judge or be it judges or the clerks or any other person, right? Lawyers, advocates. We cannot expect them to be techno savvy suddenly. So it will take time, and that is why it is happening in phases. Now, recently, in September, uh, third phase of this e-code project actually started. Now, it is going to be only for constitutional bench. Okay, now this is the cashier constitutional bench. Remember this. Now, what is constitutional bench? Now, if we go to the background of it, we'll find its background in the Constitution of India under Article 145, Clause 3, right? Wherein it has been mentioned that any bench or say when there is any question of law, right? When there is an issue of substantial question of law that comes for the interpretation in the court, in such case it becomes important for so basically it is an obligation of the court to ensure that there needs to sit at least five judges bench, and that bench will be called as constitutional bench. Okay, substantial question of law, that is the keyword here. Now, why is it all very important? As I told you, the Supreme Court has been quite keen towards it since a really long time. And in 2018, there was this case wherein Supreme Court proposed. Basically, they said that that these live telecast of all the proceeding that is happening in the court, it will help people in a right to access to justice, right? Which is right to access justice, which is one of the an important part of Article 21, that is right to life, right? Right to have the access to justice, right? So people will be able to see how it is happening, so they'll find justice to be near them, right? Other than that, Supreme Court has an e-committee that is working on setting up certain, model rules and regulations for live streaming and recording of the court proceeding. And apart from Supreme Court, there are six high courts also, wherein we are seeing, we can see live streaming of the procedure that is happening on YouTube. Okay, and what all high courts do we have? They are Gujarat, Odisha, Karnataka, Jharkhand, Bihar, and Madhya Pradesh. Right? We are looking forward to more of high courts. However, these are the only high courts that are, uh, you know, telecasting their uh, court proceeding live on YouTube. Okay. Now, let's move on to the next uh, update. Now, this is again full of concepts, right? And let's get into the concept first. It is about changes in IBC. IBC is insolvency and bankruptcy case, bankruptcy code. All right, it came in 2016, and there's this body, Insolvency and Bankruptcy Board of India, that is the main body, that's the head body of this IBC. Now, recently they have proposed certain amendments, right? So they have amended certain provisions of IBC for two purposes. First is to fasten the changes, and second is to maximize the recovery. Now, what are they actually talking about? Let's understand that first. What is IBC? IBC is Insolvency and Bankruptcy Code in very simple bhasha. Basically, there are, let's take an example. There's a company A and there's a person B, right? Or say there is an investor B, right? Suppose company A takes some loan from the investor B, right? And later on, they take that loan, but they are not able to repay it. And now they are in such a situation, they are in such poor situation, such poor condition, that even if they sell all their assets, they won't be able to repay the loan to investor B, right? So in such case, uh, one becomes a lender, that is, investor becomes a lender, and the company A becomes a corporate debtor, right? So in such case, now person B, that is investor B, can go to the NCLT, can go to the tribunal, take a complaint against the corporate debtor, that is company A, saying that, listen, I paid this person A, company A took this amount of loan from me, and it's been such a long time, they are not paying it back to me. I'm not getting it back. So I got to know that they are uh, not just less of funds, they don't just have less funds, but even if they sell all their assets, they don't even have the assets that can accumulate to the amount that they took for that they availed loan for, right? In such case, there is this entire procedure that actually starts. Okay, insolvency resolution process. That now that is a different topic. We are not going to get into that because that is not what is required for your understanding. So that is an wherein there is one person who is appointed. Okay, so court will appoint this person X, person Mr. X. Mr. X would be called as resolution professional. Again, about whom there is this amendment that has come. Now he will be making plan as to how recovery and all should happen. Simple, right? One person is not able to give money to other went to the court, said, please help, sir. Court said, okay, I'm appointing this person. He will do all the due diligence of the company, and he will try to repay you maximum amount that is possible. Simple. Okay. In the most simplest way, this is how I can explain it to you. Now the thing is, what kind of changes are we looking forward to? First is that even if that resolution professional, he's supposed to make a resolution plan. Okay, so basically the amendment says that even if there is no viable resolution plan that can be made for that company to repay, okay, even then, in such case, the creditor, okay, the lender, the creditor, who is the creditor here? Creditor is the investor B. Now that creditor can directly sell the properties of company A. Whatever was given to him, he can separately sell it. Previously, it was not allowed. Okay, previously everything was used to be on hold, and only after resolution professional, means I'll call him RP. Only when RP would tell it to the court that, okay, sir, this is the plan that I have. We can go ahead with it, and court would approve it, and then only the selling of assets and properties would happen. But now this is not the case. Now what happens? Amendment says even if there is no resolution plan, that creditor has certain collateral. That creditor has some papers of the properties. Now that creditor can directly go and sell the property to get back some amount, right? To recover some amount. That is one. Second is they have proposed, or they have said that these RPs should be paid according to the performance. Because what happens sometimes, RPs are not very much interested in the case or in the company, right? Maybe the company has gone so bad that RP knows, RP has lost confidence that, okay, I will not be able to recover money from this company. So they just make any plan which may be viable, not be viable. It may work, not work. So there are chances that they would just randomly make some plan and present it to the court to get rid of the case. But now it is not the case. Now the amendment says that RP will be paid according to the performance. Now there would be certain parameters on the basis of which they should be paid. As a koi, there should not be any fixed pay that, okay, even if they don't perform well, they should be paid well. Or if there is any RP who is performing exceptionally well, in such case they should be given incentive for that also, right? To encourage RPs to perform in a better way. And third is that it should be the primary role of RP to ensure that corporate debtor should revive. Okay, it's not just to get money out of them and give it to the creditor, but also to ensure that such company should revive out of that condition, that poor condition, they should be revived from that condition. Such should be the plan. Other than that, last year also there was this amendment wherein uh, this entire procedure of resolution process, right? Insolvency resolution process, wherein this RP wala thing happens. A separate procedure was actually allotted for MSMEs separately. Okay, so that is what it is in very simple language. Then comes death penalty. Now, which can be called as capital punishment also. There have been a lot of discussion on death penalty and capital punishment since a really long time. This tussle has been happening in several courts, high courts, and Supreme Court, right? So recently there was this question in the in a constitution bench of Supreme Court, wherein the question was how should we decide whether death penalty has to be given, or the death penalty that has been already given to the accused, it is meaningful and real and effective. How will we get to know about it? So Supreme Court simply said that we'll get to know, or we can determine that the death penalty that has been given to a person, to an accused, is meaningful, real, and effective when we get to hear about the mitigating circumstances that such case has. Now, let's get to understand what are these. First thing first, court said that, listen, uh, death penalty is an extreme penalty, right? So it is a very valuable right of a person to live. And when you are taking that right from a person, it should always be backed by some real solid grounds, right? That is one. Second is under under section 354 subsection 3 of CRPC, it is mentioned that whenever court is pronouncing any death penalty to any accused, such court should always give it in writing as to on what ground that court thinks that such maximum penalty has to be given to this person. What is that? What are those factors on the basis of which the court came to the point that this person should not at all be given any right to life and he should, ultimately be given death penalty, right? Because death penalty is the maximum penalty, so they'll have to justify it in writing. Now, there are two very important cases. Bachchan Singh case versus basically Bachchan Singh versus State of Punjab case, and second is Machi Singh versus State of Punjab, both of them from Punjab. Now, in Bachchan Singh, the rarest of the rare doctrine was talked about, okay, wherein it was said that since death penalty is the maximum penalty, right? So it should be only pronounced in rarest of the rare case. Mean in such a case wherein the offense is so intense, right? There are so many factors which all accumulate together and makes it a very rarest of the rare case, means which is not at all, which cannot be expected from the humanity at all. In such case, death penalty should be given. And Machi Singh case was an extension to this case, wherein this rarest of rare doctrine was explained uh, in an extension. All right, so wherein it was said what kind of things should be considered, right? Because of course, when court says that okay, there should be certain comparison that has to be done, we need to know on what ground, on what factors are we going to decide it. So what kind of questions have to be asked by the court? First is, what was the manner in which the crime was committed, right? How brutal it was. Was it so brutal that it makes the way the crime was committed makes it rarest of rare case? Is that so? Second, what was the motive of committing the crime, right? Third is, what was the intensity, what was the severity of the crime, and who who was the victim? Yeah, like for example, if the victim was a child, or a victim was an insane or lunatic person, or a victim was a disabled person, right? So these are the cases that makes the court question the humanity. So, or shake the conscience of the court. If such are the case, in such case, rarest of rare doctrine can be evoked. Other than that, court will also look into other side of it, that is mitigating circumstances, means wherein court can mitigate the chances of pronouncing death penalty. How? If court will see, court will basically determine, is there any possibility to reform this particular accused by sending him to rehabilitation or for any such program wherein he or she can be reformed? Is there any possibility of reformation or rehabilitation with this person? And second is, what is his mental state or health? Yeah, so that is something again that can be taken into consideration for understanding, to get a better understanding of the motive and the severity and the situation circumstances in which the crime was committed, and accordingly the death penalty has to be given, right? So it's a very interesting discussion. This has been, I mean, there have been certain discussion. If you are reading newspaper, you would be aware that there have been certain discussion on this line also. We keep getting such articles in the newspaper about the capital punishment, death penalty, Machi Singh case, Bachchan Singh case, right? So that was it for today's legal update discussion. I hope this would help you. If you have any question, if you have any doubts with regard to anything that we discussed or even outside this, please put it in the comment box. Thank you so much, everyone. Take good care of yourself.